Hello, hello, hello. Welcome to our neck of the woods. Before I get started today, I want to address an email that we received where I was asked to look back at my starting videos and see why people used to come here in the first place. And to that, I will say, although our content has changed and evolved quite a bit over time, our intent has always been from the beginning and even to this day to help people. That has always been our intent. Okay. Um, I know we like to wax philosophical here. We like to talk about spirituality here, and we will again. Um, but when we started the Foundations series here, I didn't think that it was going to take me that long to read the book, honestly. I thought it might take me 2 days, 3 days. And I'm sorry for my vocal cords not being strong enough to read for hours and hours. However, that being said, we share this information for part of the bigger picture, right? Emotional, mental, and spiritual well being are very, very important. But knowing how to take care of yourself in the physical is also important. So, all of these things tie together, even if many people don't think they do. And that's okay. You know, the wonderful thing about where we are and where we live and how we act as a society is that we all seem to agree on one thing, even if we don't uphold it. And that one thing is you are titled to your opinion, and so am I, right? Our opinions do not have to agree in order for us to both have opinions, okay? And I think people tend to forget that. And I'm not casting any judgment here, okay? Um, this was just something that was mentioned in the email to me, and it really struck me because it the person that emailed me also said something about how many that many people can't be wrong, talking about missing us on other platforms. Those other platforms no longer interest me. The drama surrounding those platforms no longer interests me, and a lot of the topics that they cover no longer interest me. Um, for my own personal spiritual, mental, and emotional health, I choose not to go to those places any longer. That is something I do for myself. That is not something that concerns anyone else, right? I am not casting judgment on those people. I'm just saying for me, that no longer resonates. Okay? Y'all are welcome to do whatever you like. Um, and when you say that many people can't be wrong, I would gently and kindly remind you mass hypnosis, mass psychosis, and mob rule. So, yes, I do believe that I'm not going to step back in line just because there's a bigger group of people over there. Numbers does not give me security. That is not the person I am. If you've hung out with me long enough, you probably understand that about me. I am very well and capable of standing on my own two very strong, very grounded legs. All right. I don't need to. I don't need to think deeply. I need to think clearly. And I know that separates me from a lot of people. I'm okay with that. I'm not okay with groupthink. I never have been, and I probably never will be. We are all entitled to and allowed to have our own opinions. I can respect yours even if it's different from mine. Can the same be said from your part? And this is a question you should ask yourselves. Now, I did do another reading last night of this book, and as soon as this book is done, we will be moving on to other things. I would like to bring to everyone's attention, though, that we found new information easier to understand information last night. And I have put this gentleman's YouTube channel in the description box. If you guys want to go check him out, I highly suggest to go into his channel and start at the very beginning. Because if you start somewhere in the middle, it may not make any sense to you. Okay. And he does a very, very good job of explaining how to utilize what you need to utilize for you. Okay. So I'm going to attempt to share the second reading, and then we'll have one more reading because I couldn't finish it last night either. Shoot. Hold on. Share screen. Share screen. Here we go. Okay. Wonderful. All right. Well, let me pull this up, and I'm going to let this play for you all, and I'm going to go ahead and mute myself. Oh, wait. I don't know if I can. But I'm going to go ahead and let this play. This is the reading, and then we'll have one more reading, which will end the book. And then I probably will not be doing any more of these books unless asked. However, that being said, please utilize the links that we've given you. Go look this information up for yourself. Do you want to be sovereign? Do you want to stand in your own power? If so, check out some of this other stuff, okay? Now I'm going to try to, there we go. Oh, wonderful. All right, I'll go ahead and play this. And, yep. All right. Well, hello. Uh-oh. Uh-oh.
Hello. Welcome back to our neck of the woods.
Thank you, Anna.
This is the third and hopefully final installment.
This may, it seems to be having a problem playing, and I couldn't get it to just play the recording. So just bear with me, guys.
Installment of the book Paper Arrows, which are excerpts from Harold Griswold. I am going to push through and get this finished. I do.
All right, bear with me, guys. I don't have the best signal today. We do have storms overhead and whipping all around. I apologize. Let me pause this for a second.
I feel like this is important information for you guys.
See if we can't get it to load a little bit better here. This may just be...
I know that I'm just shoving through a lot of this. Just to get it out there. But take your time. Listen.
Ugh, this may not work. I may just have to go back and reread it. All right, well, let me do that then, I suppose. Let me pull that up and get that loaded up. And
go get the PDF, read it yourself, make notes.
all right, give me a second. This is obviously not going to work. So let me pull it up real quick here and find out where I was. I do believe we were on. Man, I made it all the way down to 57 yesterday. Okay, so I think we were on 20 something. Hold on. Give me a second here. Let me let me find my place. The recording's not wanting to work. We were on 37. Okay. 37. Oh, beautiful. All right. So here's what we're going to do. I guess I'm just going to read it again. And let me pull that screen up here. Because I had recorded it last night so that I wouldn't have to do this again. But we will do. All right. Bear with me. All right. You guys can see that? Can you hear me well? Yeah. Like I said, after we get done with this book, we're probably not going to do any more unless we're asked to. All right. Thank you, Anna. And hi, big brother. How you doing? If you're coming in late and you're wondering about the email that I addressed at the beginning of the show, rewind, watch. If you don't care, that's fine too. The only person I think that might care is the one who sent the email. And, you know, I will not be shamed or guilted for how I feel and think. And I'm okay with that. I have two strong legs. I am a very grounded person. And I'm okay with that. I don't need to accept anyone else's persecution of me. Okay. And I don't need to cast judgments. And I'm not here. I'm not. I'm simply stating facts. What I choose to do in my life is my choice. And no amount of anybody else trying to bully me back into a situation is going to change that. No amount of somebody trying to shame me or guilt me into a situation is going to change that. All right. So let's just be clear on that right from the get go. All right. Now let's finish up this book, shall we? We were on trespass on page 37 of the PDF. If you are following along, page 23 of the book. So, a trespass of any kind is a fraud upon the person or property. Any kind of fraud dreamed up to be committed on a person is, in turn, a trespass. Any kind of a fraud or a trespass turns out to be an injury to the person that has been trespassed upon or defrauded. An injury is something that you can take into court and create an action on. A deprivation of personal property rights is injury. An injury is entitled to compensation or money damages. Someone may be able to make a couple of bucks before this whole fraudulent system collapses. Maybe we can burn them in the fireplace when they become completely worthless. These actions may be the paper arrows to shoot over at Babylon and knock it down. It is necessary to review several definitions in order to define fraud. One of the words is scheme. A scheme is a design or a plan formed to accomplish any purpose at all, a system. When used in a bad sense, the word corresponds to trick or fraud, a scheme to defraud. Within the meaning of the mail fraud statutes, It is the intentional use of false or fraudulent representation for the purpose of gaining a valuable undue advantage or working some injury to something of value held by another. That fits all the things that were just discussed, such as motor vehicle registration, Social Security, voter registration, birth certificates for the children, and other schemes to gain a property value interest in whatever property is identified on the instrument. This whole thing sounded like a sham, so I decided to look up that word. Sham means false, a transaction without substance that will be disregarded for tax purposes. That means that they cannot tax something that is fraudulent because fraud also means false. This last point by itself could be enough to free people from the illegal tax system. Since the whole scheme of taxation in this country is a sham, the law says it to set it aside or disregard it. Chief Justice of the Supreme Court, Cardoza, in 1944, referred to the 14th Amendment as a scheme of forced liberty. Today, we are all finally equal, more than before. We all are property and all equal since we are all held by another, the government, through contracts. Deceit is a fraudulent and deceptive misrepresentation. It is an artifice or device used by one or more persons to deceive or to trick another who is ignorant of the true facts to the prejudice and damage of the party imposed upon. We are creating a basis for an action here. By explaining how the deception and fraud took place, we can then show that we have cause to be compensated for the injury that resulted from the deception that they perpetrated. That definition of deceit mentioned the word artifice. An artifice is an ingenious contrivance or a device of some kind, and when used in a bad sense, it corresponds to trick or fraud. The instruments of the systems mentioned before, such as Social Security, voter registration, and all the rest, would certainly fit into the definition of an artifice as being a device of some kind to trick or perpetrate a fraud because you were tricked into using these devices, and you have been given up your property for them to hold to the detriment or prejudice of yourself, the party imposed upon. These documents that the government calls valid are artifices. They constitute a fraud. Fraud is an intentional perversion of the truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right. When you file your deed in the public records, the court, you surrender the legal right to the property. By the artifice, the application, the misrepresentation of law, you are induced into that. You had better do these things, or you will be arrested and put in jail if you refuse to do them. So you did them under duress. Actionable fraud is deception practiced in order to induce another to part with property or surrender some legal right. It is a false representation made with the intention to deceive. Just a moment, please, people. Give me 1 minute here. All right, where was I? All right, so let me just start here again at actionable fraud. I'm sorry. Actionable fraud is deception practiced in order to induce another to part with property or surrender some legal right. It is a false representation made with the intention to deceive. It may be knowledge of truth of a statement which is false. In either case, an essential ingredient is the falsehood intended to deceive. To constitute an actionable fraud, it must appear that the defendant made a material misrepresentation, that it was false, that when he made it, he knew it was false, or made it recklessly without any knowledge of its truth as a positive assertion. that he made it with the intention that it should be acted upon by the plaintiff, and that the plaintiff acted upon it in reliance upon the truth that he anticipated it had, and that the plaintiff thereby suffered an injury. If you study that closely, it sets up the basis of your whole case. Because we have been injured by the loss of our property by being compelled by misrepresentations of law into participating in all of these government things that identify our property, and we lost the right to our property, we have suffered a loss because of their misrepresentations. They cannot make you contract with them by any means. No law can be passed that states that you have to make a contract with them. But they are getting away with this stuff because we are afraid of them. And they are going to get away with it, and you are never going to win as a defendant. The only way to win is to go after them for fraud. If you are the plaintiff and they are the defendant, and you accuse them of fraud, and you ask for $100,000, it is going to scare them so bad that they're not going to answer you. A failure to answer a case is a win. The court has backed off the case in Michigan for now. They're not going to play with this thing. They're afraid. In that case, Mr. Sapp, if you remember, that's a realty thing and an IRS thing, cannot get the court to sign an order for possession. He is going to lose his $13,600 that he paid the IRS for the property, since he cannot take possession of it. He is going to have to sue the IRS to get his money back. He is definitely not happy about that. An injury is any wrong or damage done to another in his person, his rights, his reputation, or his property. If you have received any kind of an injury, then you have the right to file for a compensation in the court action, even against the government. A refusal to answer something is silence. In the court case of U.S. versus Tweel, 550 F, Section 2D 297 from 1997, the judge said, silence can only be equated with fraud where there is a legal or moral duty to speak, or when the inquiry left unanswered would be intentionally misleading. We cannot condone this shocking conduct by the IRS. Our revenue system is based on the good faith of the taxpayers, government workers, and the taxpayers should be able to expect the same good faith from the government in its enforcement and collection activities. During the oral arguments, counsel for the government stated that these practices of silence were routine. If that is the case, then we hope our message is clear. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately. We just learned that fraud is actionable, and we could create a case with fraud as the basis. Silence by an official or police or anyone else that will not answer your question results only in an attempt to defraud you by some scheme to defraud, and is itself grounds for an action, just as fraud is actionable. There is another case that lines itself right up with the Erie Railroad decision, but it also includes some real interesting comments about the situation that the government put itself in by dealing with these security instruments, such as deeds, certificates of title, and insurance policies like Social Security. Those instruments are called security instruments. The fact that the property is identified on there secures the property interest that is identified to the name of the party appearing thereon. That is why they are called security interest. The Clearfield Doctrine refers to the Clearfield Trust Company versus U.S. 31S U.S. 363 from 1943, and it expressed the government descends to the level of a mere corporation and takes on the character of a private citizen where private, corporal, commercial paper securities are concerned. That means they do not have any immunity. They are equal to me and you. They are right on a level with us. If our name appears on the security instrument and their name appears on the security instrument, they are the same as us. They have no more rights than we do. We have no fewer rights than the government does. Most people think that the government is superior. This case states that the government is equal. Note, falsely elevating the government to our level is really stretching it. Quoting Clearfield again, for purposes of suit, such corporations and individuals are regarded as an entity entirely separate from government. Very interesting case. Now we can understand why the civil rights legislation waived all immunity for government agents. The only way that they are committing a deprivation of your rights is by written instruments. Everything that they do to you is based on some written instrument. Everything. The court cannot acquire jurisdiction over a case unless there is a written instrument involved in some type or another. There has to be a contract, the agreement or the assumption of a contract or agreement, such as residency. Residency is a conduct, and they always have to establish residency in order to prove to the court that it has jurisdiction over an issue and the person in front of it. A man in Tennessee would not admit that he was a resident of Tennessee, and the judge got so frustrated that he even asked the man where he slept in order to establish residency. The judge was trying to get him to admit that he slept in Tennessee to establish residency. Finally, the judge threw him out of the court. He could not establish residency. When he could not establish residency, he could not prove jurisdiction over the man. You can put together a good civil rights case showing and exposing how the fraud created the injury. You can show that they are equal to you without their having special or particular immunities because there is commercial paper involved. The commercial paper involved consists of Social Security applications, IRS 1040 forms, vehicle registration applications, and other license applications and various other forms used by all governments and at all levels. These government entities, such as the IRS, are all equal to you and have no particular immunities. By their silence, they have proven their involvement in schemes to defraud you. This action, according to the Supreme Court, cannot be tolerated by the courts. Triple damages may be in order here. A tax bill tripled could be awarded. The courts would not agree with it. The courts know racketeering when they see it. RICO may apply. Look at how this fraud works and fits into some of the law. There is a statute called the Federal Tax Lien Act of 1966. It has been codified in Title 26, Section 6323 in the United States Code System Services, under Section 6323 N5, there was found to state the purpose of the Federal Tax Lien Act of 1966, which is codified 26 U.S.C. Section 6323, was to fit tax liens into the priority scheme of the Uniform Commercial Code. This came right out of the Book of Laws, the USCS. This is not someone's opinion. It is in the statutes and the codes. For all of those that think that the UCC does not fit into the IRS code and cannot be used simultaneously with it, that is what the code states. Title 26 is the IRS code. Read it again. The Federal Tax Lien Act was created to fit tax liens into the priority scheme of the Uniform Commercial Code. Okay? Continuing from USCS 6323, the purpose of requiring filing of a notice of federal tax lien was not to create the lien, but only to maintain its priority over certain other liens. The fair intendment of the predecessor of 26 USC section 6323 is to permit the transfer of property, both real and personal, belonging to the person who has neglected to or failed to pay the tax without a real lien of government attaching the property. People have been saying for years that a notice of tax lien is not worth the paper it was written on. Continuing the quote, predecessor to 26 U.S.C. Section 6323 was an act of self-abnegation upon the part of the government in the collection of the taxes by which it must abide. There is no question of strict versus loose construction that arises. There is no room for construction as predecessor to 6323, as classes of persons was specific. Now, I want to let you know abnegation is the act of denial. To abnegate means to deny or refuse a right. It is from the Latin word abnegatus, which means to deny or to refuse. That means it is set in stone and cannot be changed by construction as to the class of person that the federal tax lien can be laid against. Now, remember, a person is a corporation, right? Pardon me. Cross-reference. See section 6331 titled Levy and Distraint. Authority of the Secretary. If any person liable to pay any tax neglects or refuses to pay the same within 10 days after a notice and demand from UCC, used again by IRS code, it shall be lawful for the Secretary to collect such tax and such further sum as shall be sufficient to cover the expenses of the levy by levy upon the property and rights to property, except such property as is exempt under 6334, belonging to such person, the one who refused to pay his tax, is a lien provided by this chapter for the payment of such tax. Levy may be made upon the accrued salary or wages of property of any officer, employee, or elected official of the United States, the District of Columbia, or any agency or instrumentality of the government of the United States or the District of Columbia. The state of Georgia or any other named state is an instrumentality of the United States. State of, with any state name, is a government corporation of that state. Georgia is not. The state of Georgia is the government of Georgia. This is an instrumentality of the United States government. Any named county of government is an instrumentality of the state of government, which is an instrumentality of the United States government. That shows the connection of the local governments with the federal government, since they are all agencies of the one above them. If you work for any phase of government whatsoever, you are covered by the connection of the agencies to the federal government. You are covered by that statement above, and there is a period behind that statement as was stated to whom it applies. It does not go on to name anyone else as to whom it applies. The statement is very specific. Tax liens can only be laid upon government officials, government employees, and government corporations, not sovereign people. Not sovereign people. All right? So when you get your sovereignty and you claim that, you are no longer a government agent. You no longer agree to be the trustee name, okay? You're not acting in that capacity of all capital letters. That was part of the argument used in Dan's case to show the rest of the fraud. And that was what prompted the lawyer to say that all this stuff you brought up about Section 6331 is an argument that belongs in a federal court. We knew he was going to say that because it does belong in a federal court. It did not belong in that little court. It was not relevant to the case of a guy having a deed and wanting a writ of possession based on the deed that he got. Section 6331 is not relevant to that case, but it is part of the countercomplaint to show that he got the deed by fraud. And the setup was to say, fine, we're going to have a federal case, and this guy, Mr. Sapp, is a co-conspirator in the fraud, and we certainly hope that the court does not intend to become another co-conspirator of the fraud with the IRS. When the lid is put on that box, there is no way out. There are two ways to lay these cases out. One way is the counter complaint. All places where there is a complaint filed must be answered by a counter complaint. Rule 12 of the Federal Rules of Civil Procedure is the one that these cases are based on. The state rules state the same words as the federal rules, but the number of the rule may not be 12. It may be 5 or 10 or another number. It may also be Rule 12, as in the federal rules. You have to check the rules out for each state. They are uniform throughout the states. They use basically the same wording. Rule 12 states that you must see Rule 13. These rules run you all around. Rule 12 states, for the responsive objections, see Rule 13. Rule 13 is headed Mandatory Counter Complaints. Since it is mandatory, then that is what expresses the meaning of that. The response has to be done in the form of a counter complaint. Otherwise, it does not answer the complaint, and it is absolutely mandatory that you file a counter complaint. It goes on to explain the counter complaint has to be filed prior to the final judgment. After judgment, the counter complaint is barred. We cannot bring any old cases back by counter complaint. That chance is past. When you do not counter complain, you do not answer the complaint. Rule 13 shows how to lay out the case. It cross-references back to Rule 8. Rule 8C is titled Affirmative Defenses. An affirmative defense seems to be a contradiction of words. An example of the difference between an affirmative defense and a common law defense can be illustrated by my being accused of stealing a bicycle. The common law defense would be for me to state, "No, I did not steal your bicycle." That would be my answer, my defense. That is in common law. Now, I have thrown the burden back on the plaintiff to prove that I have stolen the bicycle. In common law, the accused is always innocent until proven guilty. If I failed to answer, the silence would have been an admission of guilt or fraud or such acts. It would not have had to go any further. It does not work that way in modern law. In modern law, the rule is presumption. The court must presume the facts of the complaint presented are correct until the defendant presents evidence to rebut the presumption. Common law must have gone somewhere. In the case here, the defendant has to prove his innocence. So he is guilty until proven innocent. That is the same way the system works. Backwards. That is why they put the affirmative defense, so that you could admit that you were guilty. Then you defend yourself by saying, "Yes, I stole his bicycle, but he parked it in front of my house and left it there for 6 months. I thought he abandoned it. And so it is his fault that I took the bicycle because he left it there for me to take." That is an affirmative defense. I am not guilty. I created rebuttal evidence. The court does not know until you tell them. That is why you must affirmatively answer. They do not know that the other party is negligent, that he perpetrated a fraud. They do not know that the other party contrived or created a device or an artifice to get you involved in something like this. This fits exactly to show how you can be induced into these schemes or shams, and your property has been stolen and you become liable because you did not use your property correctly. Once they are the holder and they put it up as collateral, they must make sure you maintain it so that the value of that collateral does not drop. They might have to pay back the borrowed money. So they make laws regulating how you take care of your property. That is what the automobile laws are all about. That is what building permit laws are all about. They want to make sure your property is well maintained so the collateral value remains high so that they do not have to pay off the debt for the money that they have borrowed against it. I do not like the fact that they have taken unfair advantage of me, and I'm mad at myself for letting them get away with it. I let them do it, and now I am in defensive mode. The government's claim is that I did not abide by the things that I agreed to do. I did not even know I agreed to do most of these things. Look at the front of the certificate of title. It states, The above named person is the owner of the vehicle described hereon and agrees to operate this vehicle in accordance with the laws of the state of Georgia. They tricked me into agreeing to go along with their laws. Now they will take me into court because I did not do what I agreed to do. Not because I did something wrong, but because I did not do what I agreed to do. But I only agreed to do it because you did not tell me what kind of scam you're getting me into. And under the law, they have a good faith obligation requirement to tell you about such scams, that they are using your property to borrow money against it, and that you are going to have to keep that property maintained under their rules so that the value of the property is kept up. They did not tell me about all of this. If they had told me about all of this, I would definitely not have done it. According to Title 26 USC, the IRS tax collection laws, Section 911, the corresponding CFR site is 1.991 under the heading Citizens and Residents with Foreign Earned Income. We know that the United States is a foreign corporation with respect to a state, small s, because the state is a foreign corporation to the United States. See again, New York, R.E. Merriam, 16th Southern Court, 1073, that held that the U.S. is a foreign corporation with respect to a state, small s. Okay? Enright versus U.S. shows that the federal government is a state, little s. Okay? If I live in the state and not the state of, because I am not a member of the state government, then I am foreign to the United States and the state of, due to the fact that the state of is not foreign to the United States. The state government is not foreign to the United States government, since it is an instrumentality of it. This is the result of the 14th Amendment in 1868. Only the state with a small s is foreign to the United States, and that is the people that live in the vast countries known as Georgia, Arkansas, Florida, Texas, and the rest of the 50 states, not the state of. The people are the state. The governments are the state of, the corporate entities, the corporate body politic. We found a case in Maryland that stated it was dismissed for want of jurisdiction. A way to find out how they have jurisdiction is to look at why they did not have it. Look at it from the other side of the coin. The case was about a man who sued the state of Maryland Board of Education in Carroll County. It was dismissed from Carroll County Circuit Court for the state of Maryland for want of jurisdiction. This was the state of Maryland Circuit Court. This would mean that you could not file a case in the circuit court against the state of Maryland. We did not understand. So we looked up the cross-reference case, and it was about another man who brought a case against the Board of Education of the state of Maryland in the Baltimore City Circuit Court for the state of Maryland. It was dismissed for want of jurisdiction. We were getting the idea that either you cannot sue the state of Maryland or you cannot sue the Board of Education. Why were these cases being dismissed for want of jurisdiction? Why were the cases being dismissed when the people were suing the state? We found another cross-reference to a case that stated, see this case for establishment of jurisdiction of suits against the state of Maryland. It stated that all suits against the state of Maryland must be filed in the Anne Arundel County Circuit Court for the state of Maryland. That was it. Annapolis is the capital of Maryland, and it's located in Anne Arundel County, and the corporation known as the state of Maryland has its headquarters there. You must sue in the jurisdiction where the party is located. The state of Maryland is located in Annapolis. The state of Maryland is not located in Maryland. It is not Maryland. It does not comprise all of Maryland, but it is a corporation in a building in Annapolis in Anne Arundel County. Now, guys, give me a break. Give me a second here. I need to Grab something to drink real quick. Please talk amongst yourselves. Hey, Tim, good to see you. Hey, Tracy, nice to see you, Shep. Good to see you. Oh, I love you too. All right. Anybody else that's just following along with us? If you guys would just talk amongst yourselves for a few minutes and give me a moment, I will be right back. I'm going to mute myself and leave this screen up for a second. All right. Thanks for bearing with me. Okay. Hello to the lurkers. That's right. Well, I mean, if you're listening along, hey, we've lost a lot of people over me reading this book. And I don't understand that because I'm looking at this from bigger picture, the whole ball game, not just one or two little pieces of it. So, all right. Where did I leave off? The state of Maryland is not a piece of land comprised within the boundary lines known as the state lines. As noted in the state constitution, that is Maryland state, it is nothing more than an office for the corporation's headquarters located in Annapolis. Hey, Pumpkin, you want to turn that down some? This is true for all the 50 states, not just Maryland. The state of comprises only that corporate entity located in an office in the respective capital cities of each of the states. It is just an address and only an address for an office. One point to remember is that when filing a suit against a government official, the suit must be filed where the official is located. And in the case of Haffer versus Mello, the U.S. Supreme Court decided that Mello and his fellow employees had an absolute right to sue Mrs. Haffer for firing them from their jobs. She had no governmental immunity whatsoever, only because they sued her in her personal capacity. Had they not sued her in her personal capacity, she could have claimed immunity in her political capacity. The court explains clearly that it was not a matter of what capacity she was operating in when she did the act that she was being sued for, but the difference was the manner in which the case was filed. It was filed in her personal capacity, and she had no immunity because of that wording. Do not sue them in their political capacity, but sue them in the jurisdiction where they did the act. Some of these cases involving non-resident aliens are going to require counterclaims against these governmental people in their personal capacities. The reason is that everyone in the government has the same silly beliefs that we all have had for all of these years, that we are all citizens, and they think that they are doing the right thing by trying to collect the tax and other fees from all of us and themselves. If you are a doctor, dentist, electrician, contractor, nurse, or anyone with a license, you promised to obey the rules to get that license from the government. You signed your name on the document and made yourself a party to the government. You became resident within the government because now your signature is on a document that is in their files. So colorably, you are now within the government. Now you are not a non-resident alien, you are resident. But the source of income is what determines whether or not a tax is due. It is not always determined by your status. A non-resident alien has both his status and the source of income to show that there is no tax due on the money earned. It is not so much that the income was made as it is whether or not it was made from sources within or without the United States, the government. Likewise, foreign earned income from a state or other people that are in that state that are foreign to the United States would be from a private source foreign to the government. It is not taxable for residents or for non-residents of the government. Even though you may have a license to work, which would ordinarily make you taxable, you have to pay taxes only on money earned from within the government. If you worked for me and got paid for it by me, you would not have a taxable income. If you built an addition to a military base and got paid by the government for it, you would have a taxable income. So you would fill out a 1040 form showing the taxable income on the 1040 form, and according to section 1.911 CFR, explaining section 911 of the IRS code, it states that you fill out a 2555 form, which shows the gross income, the total income that you had, and breaks down each source. It allows you to give the explanation for why the total amount of the 1040 form equals the amount that was from sources within the government. And that part was the only part that was taxable. And that is why the little bit is all that is shown on the 1040 form. There is an exclusion amount there. They allow you to deduct only $70,000 a year in private source income. Anything over and above that, they figure you made that due to your privilege that you got for having the license. And they ask you for a tax on that amount over $70,000. There are not many licensed people that have income from private sources that would be greater than $70,000 a year. There are some, but not that many. Most people would be exempt from taxes on their non-government income up to $70,000 a year. You must be ready to prove all of these points that we have mentioned so that if they come down on you, then you can counter them. The IRS filed a summons and complaint for a man in Delaware to come in and show records and handwriting examples. So we went in, showed the records, gave the handwriting examples. The records indicated the W-2 forms that he had from the corporation he worked for. We explained that he was not an officer of the corporation that he worked for, and that he was a worker, and his income was not effectively connected to the United States. The officers of the corporation may be, but he was not an officer. But this is the amount of income. We did not try to hide that. The IRS said that they would be in touch. We went to the U.S. District Court, filed a summons and complaint for the IRS to produce evidence that this man's income was effectively connected to the trade or business within the United States. We used the very same document that they used and summons and complaint. They asked for books and records, so we asked for books and records that show that the money earned is from the source within the United States. The IRS cannot prove this. They will not be able to proceed in the criminal case. That is called countering them. This is just like a chess game. When you counter a complaint made in court, the prosecutor that would originally come against you becomes your attorney in the counter complaint. The counter complaint must be ruled on first. If it wins, the original complaint goes away. If the original complaining party does not answer or show up in court, the case can be dismissed for failure to prosecute in a timely manner. When addressing any criminal matter, such as disturbing the peace, if you are charged, the rules state that all criminal cases must originate in the lowest level court. So you can go to the lowest level court and ask them for a form from a criminal complaint. Then check in the criminal code statutes for your state. Look up what kind of law they broke and then charge them. If they fail to show up, the case will be dismissed with a motion based on failure to prosecute timely. There is a civil rights decision, County of Riverside versus McLaughlin 111, South Circuit, Representative 1661 from 1991. The Supreme Court narrowed down the Fourth Amendment meaning of a right to a probable cause hearing so that you are safe in your houses and effects and property and papers. They noted that you could be arrested and held on a claim of some kind for not more than 48 hours unless there was proof of probable cause. You must also be arraigned properly and given the right to a lawyer, which matches what was held in the Miranda decision. So they combined Miranda and said you have to be arraigned in 48 hours. If they are going to do that, then we should be able to demand a probable cause hearing. Another man in Delaware got locked up for driving without a license. He demanded a probable cause hearing when he was arrested. They refused. He demanded it again in jail and put it in writing and gave it to them. They continued to ignore him, but he would not sign the bail release. This is very important. We were getting ready then to put together our first civil rights case using the McLaughlin case when the justice of the peace decided that what he would do is send him from the lower court, the JP court, to the next higher court. He appeared the next day in front of the higher court, the Court of Common Pleas in Delaware. The judge called the case. He said, "Are you Mr. Keating?" He said, "Yes." The judge then asked, "Do you understand the charges against you?" Mr. Keating replied, "We are not here to talk about the charges against me." The judge said, "Oh, yes, we are." Mr. Keating said, "No, sir, we are not. If you will check the records in your file, you will find that I did not ask to come here. I have signed no waiver of my right to be heard in the Justice of the Peace Court. And I have signed no request to come to the Common Pleas Court. This court does not yet have jurisdiction. The Justice of the Peace sent it over here, and I did not ask to come over here or sign anything to agree to come over here to this court." The judge looked through his file, could not find anything that would be a request or agreement to come to his court, and said, "You are right. This court does not have jurisdiction. This case is recommended back to the Justice of the Peace." The Justice of the Peace could not get him to sign the consent paper at his court, so he sent him to the higher court. He was hoping the higher court judge could coerce him into signing his consent. The case went back to the Justice of the Peace Court and has this probable cause demand still there. The probable cause demand stated that Mr. Keating wanted the plaintiff brought in according to this written demand. And further, it stated that the complaining party must appear at the probable cause hearing to show cause that this complaint is not based on the fraud, misrepresentation, and coercion emanating from the unlawful conversion of the collected taxes from the people at large and using that tax revenue to purchase the land, construct roads thereon, and then deeding the said land to the corporate state government of Delaware, which results in a profit or a benefit to the corporate state by deeming it a privilege to use that property. The Justice of the Peace was so mad and frustrated that he was throwing books and screaming. He put on a scene and threatened Mr. Keating that he would never get out of jail if he did not sign the bail release. He said, "If you do not sign this today, I'm going to make the bail $1 million. You will never be able to get out of this jail." Mr. Keating said, "I do not give a damn if you make it $1 billion. I am not going to waive my right to the counter complaint, and I am not going to consent to your fraud and coercion." The Justice of the Peace said, "Take that man out of here. I'm going to write an order that you will show up in Court of Common Pleas on the 12th of next month. Release him." Now, what good will this do? The Common Pleas Court already knows that it does not have jurisdiction. It said so. He was so frustrated that he could not get this man's consent. There is no jurisdiction in any court unless you sign in. A civil complaint has to be signed by you in order to get the complaint going. That is how you create jurisdiction for the court, by signing the complaint. In a criminal complaint, such as a traffic ticket, the cop signs the complaint, but you sign your consent. And if you do not sign in your consent, they cannot put you on trial. Here is the rule in Federal Rules of Criminal Procedure. Rule 19. You must watch how it is hidden in the words. Rule 19 states, in a district consisting of 2 or more divisions, the arraignment may be had, the plea entered, trial conducted, and sentence imposed if the defendant consents in any division at any time. Then it states that Rule 19 was abrogated, not repealed, effective July 1st, 1966, because of the 1966 amendment to Rule 18, eliminating division venue of. That will change the whole perception of what is actually stated here. We will read Rule 19 again, but this time we will read the amendment states and eliminate division venue, as it was originally mentioned in Rule 19. We will then start reading at, the arraignment may be had, the plea entered, trial conducted, and sentence imposed if the defendant consents. Read it again. The arraignment may be had, the plea entered, trial conducted, and sentence imposed if the defendant consents. If the defendant consents, do not consent, do not sign. If you do not sign, they will threaten you with anything in order to do so. They will tell you that you will never get out of jail. A good response to that is, I just hope the food is good. I needed some rest anyway. That backs them off. Another guy had already been arrested and put in jail for criminal charges by the IRS of willful failure to file that were filed in the district court, and he had signed the document known as Order Setting Conditions of Release, which is what he had to sign in order to be let out on bail. He signed it. Here is what he agreed to. Acknowledgement of the defendant. I acknowledge that I am the defendant in this case, that I am aware of the conditions of release. I promise to obey all conditions of release, to appear as directed, to surrender for service of any sentences imposed, and I am aware of the penalties and sanctions for the above. I agree to appear for the sentence imposed. Why bother with bail? Why bother with the trial? If anyone would sign this, they should just tell them to go ahead and put me away, and when the sentence runs out, you can let me go. Trials are expensive, and so are lawyers. The best thing to do would be to skip the expense and go to jail. There's no need to pay a lawyer. That is a standard form. If you sign to get out on bail, you will sign this form. If any of you have been to jail and got out on bail, you sign this form. That is how you consent, by signature. So we were refusing to sign. This guy in Pennsylvania said that he wished he'd heard about this a couple of weeks ago because he had just gotten back home. They had arrested him and he had signed the paper for his release, and he wanted to know what he could do about it now. There is a section in the UCC that addresses revocation of signature on documents. When you feel that the signature was coerced out of you, or by some fraud or intimidation you were prompted to make a signature that you would not have normally made on your own, that gives you right under law to revoke your signature. This fellow named Reese looked it up and used it. He revoked his signature on the bail release document. Now he was worried that they may come throw him in jail because his signature was removed from the agreement, and they may want to take him back to jail until the trial. But that never happened. So he showed up at the trial, and the judge called the case to begin trial, and the guy told the judge he could not start the case. The judge asked why, and Reese told him he had revoked his signature on the order setting conditions for release. The judge turned to the United States attorney and ordered him to come back in 10 days and show proof that he had jurisdiction over this man. The U.S. attorney came back in with a crying plea of objection under Rule 12. She filed a counter complaint against the judge's order, not against our man. He had not done anything. It was filed against the judge's order. She complained that the jurisdiction had been established by Title 26, Section 7401. That was not true, but we missed that fact at that point. We should not have countered her counter. But because in addition to Title 26, she would need his consent. But we forgot to do that. So the judge let it go by and ordered the trial would start. They arrested him the day before the trial and made sure that he was in court for trial the next morning. They took him to court in handcuffs, but when they got him in there, they took the handcuffs off. They picked the jury and got the trial started. The U.S. attorney got up, gave the opening argument to the jury, and the judge asked Reese if he had any opening argument to the jury. He answered by saying that he was not going to have anything to say to the jury or anyone else until they can prove that they have jurisdiction. He told the judge that he did not have his signed consent, and when they come up with a consent form that he signed that is not revoked, he might participate in their trial. In the meantime, they had not established that they had jurisdiction. The judge said, "I know that. We will answer that question a little later on. Are you going to talk to the jury or not?" Reese replied, "No, I'm not talking to anyone." The trial continued and the witnesses were called, and one witness told the court that Reese had an income, but the witness did not put in any evidence as to the source. If a trial is necessary, be sure to require them to produce evidence as to the source. If they do not proceed with the trial, keep on questioning if they have any evidence to prove jurisdiction over the person. He did that. The judge said, "There is no jurisdiction established yet over you. Ask him a question about the testimony." Reese said, "No, if you have not established jurisdiction over me, I'm not asking any questions." The trial continued and another witness was called, and then it was time to go home for all but him. He was to go back to jail, and the judge told him he would probably rather be home in bed instead of going back to jail and said, "If you will tell me that you will agree to show up here in the morning, I will order them to let you go home tonight." Reese thought about it a long time and said, "Yeah, I will be here tomorrow." At that point, the court clerk said, "I got it. It's on record." Then Reese realized what he had done. He had just consented. When he agreed verbally, it was as good as his signature on a piece of paper to come into court the next day. Reese then demanded a 10-minute recess, and with reluctance, the judge gave it to him on the third request. Then Reese went to the back of the room with the help of some of his friends. He wrote up a revocation of his verbal consent. The longer he sat and thought about how the judge had tricked him, the madder he became. He went back to the bench and said to call the court back, and the judge did so. As soon as the judge said that the court was back in session, Reese walked up to the bench, slammed the paper down in front of the judge, and said, "Here is a revocation of my verbal consent that you just tricked and coerced me into, and I am not putting up with any of this nonsense. I am leaving." And he walked out of the courtroom. The judge choked and sipped water and choked again and was not sure what to do. After several minutes, he turned to the jury and said, "This is a little bit unusual, and I am sure that you do not realize what you have just witnessed, but you see, he had a right not to participate in this trial. Tonight, we are at recess, and we will notify you later as to what time we will continue this trial tomorrow." They proceeded the next day without him and got a conviction. They called him in for sentencing, and he did not show up, so they sentenced him without his being there. They wrote him and asked him to come in for the sentencing. He wrote back and said that he did not want anything to do with the trial, and he did not want to take part in their sentencing either. The U.S. Marshals came out and got him. They took him to federal prison in Pennsylvania. Then Reese subpoenaed the judge for an order of commitment. There was not one, so he warned the marshals. He told them that they would be liable since they were holding him without an order. But they claimed that they were not liable. He told them he would get them and that they'd better go get their lawyers. They asked him if he had any health problems that they should know about. He told them he had a wooden leg and that he ate nothing but kosher food and fresh fruits and vegetables. So they brought him the foods he requested and had to replace his worn-out leg. They are holding Reese without an order. He should bring up a civil rights issue. This could develop into something big. We will see. If they try to keep us from filing these counter complaints, that amounts to an action by them causing a deprivation of our right to utilize the court. This would be discrimination against aliens. Only a government flunky can file a criminal complaint. That means that a non-governmental person is being discriminated against. Back in the 1980s, I found that aliens had more rights than citizens did. At that time, I thought I was a citizen and wondered how these aliens could have all these rights. In a book about equal protection laws of the 14th Amendment, Civil Rights Claims, there is a section called Discrimination Against Aliens. It is loaded with court case sites on aliens in battles with the government and how the government abuses their rights. In the same book, there is a section called Rights of Privacy and Personhood. To be a person is to be a governmental official, or a person could be a corporation, or a person could be a natural person. The government lawyer will take the presumption that when you admit to being a person, that you mean a person in government. That is advantageous to them so that they can prosecute you. You must clarify that you are a person not connected to government. Then you are the other person in the law and are entitled to personhood with a life plan or a lifestyle in this country. Then, in the same book, under the subject of travel, there is a court case here that says, concurring in Shapiro versus Thompson 394 U.S. 61S, Justice Stewart described the right to travel as not a mere condition of liberty subject to regulation and control under conventional due process and equal protection standards, but a virtual, unconditional, personal right. But remember, you do not have the right to travel on my property. You do not have the right to travel on anyone's private property. And if the state corporation owns the roadways, that is their private property, and you do not have a right to travel on it. So the complaint would not do you any good unless within the complaint you bring up the fraud of the unlawful conversion of the tax revenue to buy the roadways and deed it to themselves. Then that was the deprivation of your right because it made use by you a privilege with the money that they took from you and caused a deprivation of your right to travel. Instead of claiming that you have a right to travel, claim that they took that right to travel away from you by this fraud. In some states, the cops just write you a ticket and drive off, whether you sign the ticket or not. In other states, if you do not sign the ticket, you go straight to jail. In Delaware, a person can be charged with putting you under duress, and duress can be used as an affirmative defense. It is in the statutes. If you threaten to put someone in jail because they did not sign their name to a bill, then that was a threat and coercion, and that is against the law. It is true in all states. There are also criminal statutes for putting someone in jail for doing an act of coercion. So it is a defense in one mode and a criminal act in another mode. You can utilize either side of it. We are learning how to go back at these people. One of the guys in Delaware drives a truck for a living. He has been talking to the other drivers about using such things as without prejudice when signing a traffic ticket and other documents. He told them that whenever they use those words under their names, it created a problem in that document it appears on and cannot be used as evidence. The courts cannot accept that document as evidence. From Bovier's Law Dictionary comes the definition of the word compromise. And from all the way back to that time, it seems to remain constant that it may, however, be considered settled that the letters or admissions containing the expression in substance that they are to be without prejudice will not be admitted into evidence. So, if without prejudice shows up on a document, it will not be admitted into evidence. What about an expression not in substance? If you sign your traffic ticket without prejudice, then it cannot be used in court as evidence. If you do not want to get locked up for not signing it, then sign it without prejudice. When you get to the courtroom, bring it up to the judge. Don, the truck driver, told his fellow drivers about this, and one of them went only about 25 miles down the way, and a cop pulled him into a weigh station. Checked his truck, discovered that there was no fuel sticker on the truck. Some states charge $1,200 a year for that sticker. It is required to buy fuel in most states. The fine was to be $250, and he signed the ticket without prejudice, and the cop drove away. When the court date came up, the cop presented his case, and the judge said, "Wait a minute. I am looking at this ticket, and I want to know if you have any other evidence in this case." They said they did not. So the judge said, "In that case, I'm going to dismiss this case. Your ticket cannot be used as evidence." This truck driver could not have argued this case because he did not know how to argue the case. He could not have argued what was meant by using without prejudice. In fact, he did not argue it. The judge took care of it for him. He was lucky that he got a nice judge. Others are not so lucky. Another traffic case in Delaware was heard by the same level judge as the one just mentioned. The ticket was signed without prejudice, but this judge said, "I do not care how it was signed. I do not want to hear any more of your silly stuff in this courtroom. Proceed with the trial." Same issue, same level court, but a different judge. That is an example of there being no law in this country. It is arbitrary. It is anarchy. There is an absence or confusion in law all through America today. That is, by definition, anarchy. Judges have said, "The law is whatever I say it is today in my courtroom." Using without prejudice may work for you. If it does not work for you, then there is another way. There are all types of laws in the commercial law statutes of each state code. There you will find that the judge cannot alter or ignore a statement of any kind, such as without prejudice, on any document. No one can alter, remove, or ignore it. If they do, they waive their immunity because they denied you a right. A right cannot be forced into a waiver. Now, this is important, people. This is where it starts to get kind of deep about this. Here's the law that states this. Commercial statutes such as Title 15 U.S. Code Section 1693L, headed as Waiver of Rights, states, "No writing or other agreement between a consumer or any other person may contain any provision which constitutes a waiver of any right conferred or cause of action created by this subchapter. You cannot be coerced into waiving your rights." If you sign a document that has a waiver of rights on it, the document is void on its face. Nothing at all can force you into a waiver of your rights in commercial law. A traffic ticket is a commercial agreement, a commercial instrument. It is patterned after the UCC. It is even called a notice. It has a demand for payment on there. It is a commercial instrument and therefore comes under those laws. Under commercial law, they cannot force you to waive your rights. If they do in any way, shape, or form, or if they remove anything such as a claim of rights, like without prejudice or all rights reserved, that you may write on that document, they may become liable under criminal statutes in the codes. They cannot deprive you of the right that you claim, no matter what they say or how much they threaten or intimidate you. Sue them criminally. There is a right of rescission involved in commercial transactions. The only way a rescission under commercial law can be done is when both parties consent to the rescission. Both parties have to sign the agreement of the rescission. Otherwise, it cannot be done. That means you cannot rescind something on your own. You need an invitation from the other party agreeing that they will rescind something, like a signature. But under commercial law, anytime an obliger is established by the creation of a security interest agreement of any kind, and it arises under operation of law, which means contract or agreement, the law only operating after the contract or agreement is established requires that the creator or maker of the instrument put on file or in writing to you, the obligee, that you have a fixed number of days, not less than 3, in which to rescind the agreement. If this is not in the agreement, then the agreement is revoked. Most agreements that are entered into by any of us do not contain any mention about the right we have been given we have to be given a specific time period to rescind our signature, whether 3 days or 30 years. They just do not tell us that. An example, on the back of the first page of your mortgage document, somewhere close to the middle of the page, you will find a statement there that the borrower waives his right to presentment, dishonor, and protest. Those terms come right out of the UCC. If you waive those rights, the mortgage is void. Do not use this remedy unnecessarily. This could cause one heck of a mess in the banking system. But if you're losing your home or being put out of it, your family may be at the mercy of others, then you could revoke your signature on the mortgage agreement because you were forced into a waiver that they are not allowed to do under law. Now the lender does not have a signed agreement to present to the court and prove that they have a claim. We have used this process and the court has thrown the bank out. They dismissed their case from the court. The bank was foreclosing against a home where a wife and children would be on the street. It was necessary to take that action. The banks have lost every one of the cases where we have done this, and the people are not getting mortgage bills anymore. There is no mortgage. The deceptions are so intense that the wisest of men cannot know right from wrong. At one time, the Social Security system looked like the right thing to do, so I had no problem with joining. It was to be had as a way to take care of the elderly and me in later years, so we were told. But since then, I have found out that it is just a way to confiscate my property and has nothing to do with taking care of older ones. It no longer looks like the right thing to do, but what is right today may not look right tomorrow. All right. And I wanted to finish this up today, guys, but I think that I'm going to take a break for a second. Yeah, Pappy, batten down the hatches. I know you got that blizzard coming. We got the cold air already. I kind of do want to finish it, but I don't know if I can read another 20 pages right now. But I hope you guys are paying attention because this is actually some really, really good stuff that is it's things to keep in mind for those really hard places like, right between the rock and the other rock. These are legal remedies that you can utilize to help yourself and your family. Yeah, we'll have Harbor open in a little while. It was open last night too, by the way. All right, guys. Well, love and light. We'll finish this. I'll try to finish this up tomorrow, and then, like I said, probably won't do any more books unless I'm asked specifically to. But some of this stuff is really good information, and I implore you all to go look at it. Also, in the description box, you will find a link, the link to this PDF, a link to the SPC University downloads tab. As well, we just found a gentleman who can walk you through the simplest of all of these things. And his YouTube channel is in the description box. His name is Christopher Hauser. If you go and look at his YouTube channel, don't start somewhere in the middle. Start right at the beginning and follow through. And that way you have a better understanding of the information as it's being presented. Okay? God bless. Have a great day. And we will see y'all tomorrow.